Hi, my name is Joseph Esri and I'm one of the attorneys at Parman and Easterday. You're watching one of our videos where we're trying to answer some of the basic questions about estate planning. Today I'm going to talk a little bit about guardianship, what a guardian is, how you appoint one, and what that process looks like. There's really two types of guardians that exist when I'm talking to people about estate planning. The most common type of guardian when we're in the estate planning world isn't actually the one you're thinking of. The most common type of guardian is a guardian that is issued over somebody who's no longer able to make their own financial decisions or healthcare decisions, and the courts have decided we need to appoint somebody to make those decisions. This is a process called living probate. Living probate is a really miserable process. It's a really long process when we get into it. It's not the process that I'm here to talk to you about today. If you have a question about getting guardianship over somebody who previously was able to make their own financial decisions but can no longer make their own financial decisions, give us a call. We can walk you through that, or check out one of our other videos. We go a little bit more in depth on that there. The way to prevent having to get stuck in that situation is to have a financial power of attorney and a healthcare power of attorney, so that at the point when somebody can't make their own financial decisions, those documents are in place to make sure somebody can act on their behalf without having us go talk to a judge. Today I want to talk about the other type of guardian, the guardian that most people think of when they have that child, that first child or that second child. That is, who takes care of my child if something happens to me? Who's the guardian over my daughter if something were to happen to my wife and I? How do I appoint that guardian? What does that process look like? And here's what I'm here to tell you. The only way to appoint a guardian, the only way to appoint somebody to take over for you as the guardian of your child after you're gone is you. And you have to do that in a will. It has to be done in a will, both in the Missouri and in Kansas. So no matter where you live in Kansas City, we have to make sure if you have children under the age of 18, you have appointed a guardian. And that is, who are my children going to live with? Who's going to take care of, make sure my kids get fed if I'm not here, or if I and my spouse are not here to make those decisions. Another point of confusion here is the guardian doesn't necessarily have to be the person in charge of the money. There's lots of misinformation there. Some people say, oh, I want this person to take care of my kids, and I'm going to give them all of my money to take care of my kids. Other people say, this is a situation that's a little bit more complicated than that. Perhaps my sister is the best person to watch my kids if something were to happen to me and my spouse, but perhaps my brother-in-law or my father-in-law or my neighbor next door would be much better at managing the money on behalf of that kid. Your will, or your will and trust, depending on the type of estate plan you need, must be where you list out that information. Now, the role of guardian always must be in the will, and the will must be an original document that is submitted to a judge in order to say, here's who should take care of your children. Don't let there be any confusion out there about that. A lot of times people are out there making handwritten documents, or they're telling their friends and family, you're who I'd want to be the guardian. I will tell you what works the best. What the law in Missouri says is, in order to nominate a guardian, you need to have it written down in your will. And your will needs to be a valid will, written for the state in which you reside when you pass away. So if you have children under 18, we would strongly encourage you to have a will that says, here's who the guardian of my children are, and here's who a backup might be. In other words, here's the person and here's a backup. And while you're at it, pick a person to make those children's financial decisions and have a conversation about at what age those kids might be ready to receive what it is you're leaving them. If you have any questions about guardians or anything else in the estate planning world, feel free to give our office a call, 913-385-9400.